Howdy, and welcome to Chapter 2. And in advance, I apologize for my voice. We're going to talk a little bit about the process of civil lawsuits here, different ways laws are enacted, and laws from statutes and common laws. And then we're going to end up the chapter talking about a very important legal concept of standing that is required to be able to file a lawsuit. So let's talk a little bit about the process for actually filing a lawsuit and pursuing it in court. Now, in a civil lawsuit, it's a person against a person, or a person against an entity, or an entity against a person, or an entity versus an entity. In a government, in a criminal action, it's a government versus an individual, the defendant. So I want to sue somebody for something. Well, first of all, I got to have a legitimate statute or common law cause of action. Contract breach would be a common law cause of action. A statute might be their fence is on my line or something like that, encroaching on their line, and can't be within so close, or all different kinds of things. Nuisance statutes or something like that. I can't just make something up. So someone's flying a blue flag and I don't like blue flags. If there's no statute or common law cause of action, I can't sue them to remove the blue flag. Now, it starts with a plaintiff getting a document, the complaint, the pleading, and laying out their case, and then with another document properly serving that defendant. It has to be in a personal type service. There are some exceptions, but they're not important in this class. Typically, you hire a professional to do this, because if service by process is not done correctly, it blows the rest of your lawsuit away. It doesn't even matter if there's a judgment, and the judgment's been put in place for months. If you can say, hey, I was never properly served with process, right? Now, sometimes people waive process. I know I'm going to be sued. Just send me the stuff and I'll waive process. But again, all this is documented. Now, once the defendant receives that, he or she must respond to the court within a specific time. And let's say I allege 5 complaints, and you think, one's true, but the other 4 aren't. Doesn't matter. You're going to respond with a general denial. You're just going to respond to the court in writing and get it recorded with the clerk that you have responded within the specific time. Typically, it's the Monday next after 21 days or something like that in Texas. And then basically the lawsuit's been filed and you've responded. Sometimes that's it. Sometimes people never hear from it again. And the defendant may file a motion to dismiss. And, this typically, lawyers, it's a game. The judge has to accept all facts pleaded by the plaintiff as true at this point. It's highly unlikely that they're going to do a motion to dismiss at this point. And then the parties move to discovery. So we both make a list of all the documents and evidence we want, even physical artifacts or something. There's a strict deadline described in the rules of civil procedure, and each party has to provide all information in discovery as requested or risk sanctions. If I destroy evidence, that evidence can be deemed as admitted in favor to the other party. This is one that occasionally just gets companies or people trapped up because they will fail to include certain emails or something because they don't think they're germane to the topic, but they are. And then either party might file a motion of summary judgment and say, hey, judge, that other party has not proven his case. Let's just end it now. And if the defendant files it, the judge grants it, the case ends. If the plaintiff files it and the judge grants it, which again, very rarely happens, the defendant can appeal, they can negotiate back with the plaintiff. But the deal is there's negotiation going through this whole time, and most cases do not go to court because the juries are at risk and tend to settle at the court. Otherwise, they proceed to court. Now, everything that we do in court, federal courts or state court, are by civil procedure rules. I'm going to ask you on your own to look through the federal rules of civil procedure, FRCP, but I'm going to show you some interesting Texas. So let's go to our Texas. And so here's our Texas State of Texas, the judicial branch, rules and forms, and I can look at the rules of civil procedure, and they're going to have everything that basically tells you how to interact with the courts. Objective of the rules, the scope, down to agreements to be in writing, when what attorney has to do when he withdraws, an attorney just can't quit the case, and so on. And then you can look at this and it'll have the rule to tell you exactly how the rule is to be executed. So these are our rules of civil procedure. I don't know why that didn't come up right, but you can see this is quite long, 300 some pages. We have appellate procedure, how we're going to appeal. We have Texas Rules of Evidence, always a fun one. Here's our rules of evidence. We always start with purpose and scope. Let's see. By the way, when it says foreign law, it doesn't mean outside the U.S., it means outside of Texas. Methods of proving character. There's going to be methods of proving character. When a character's trait is admissible, then you've got a way that you have to proceed. Let's see another good one. Oh, shoot. Somehow I missed it. Privileges, we'll talk a little bit about that. Witnesses, your competency to testify in general. The dead man's rule. Every person is competent to be a witness unless this applies. The person's insane. They lack sufficient intellect. They're a child or they have some mental deficiency. The dead man's rule, applies only in a civil case. By or against a party, the party's capacity as an executor, administrator, or guardian, who may testify against another party about an oral statement by the testator, intestate, ward, or decedent if, because typically we don't listen to dead people testify. Okay, so let me show you one more, and that's hearsay. Let's see, where's hearsay? Oh, this is also a good one. Testimony by expert witness. You have to be declared an expert. Evidence has to be proved up. Spend some time looking through here. By the way, authentication and identification is not quite what we think about in electronic, but there's the rule against hearsay. And so hearsay is not admissible unless it's ruled admissible by a statute, these rules, or other rules. So hearsay, I can't repeat what somebody else said. And then we have a bunch of exceptions. If the defendant, whether or not the defendant is available as a witness doesn't matter. And then you have all these, and you'll hear this sometimes in a Law and Order type thing. Your Honor, hearsay, and the opposing counsel will say, exception to hearsay, excited utterance, right? Or a statement against interest, or something else, a public record, something like that. So you have all these exceptions to hearsay. All right, that ends video 1. Be back with you shortly.